So we're now going to move into the next module, which is really where we're going to talk a lot about white-collar crime. And this is a concept that some people may think they know what it means. Some people may think that it's confusing. I hope to provide some clarity and some insight here that will help you as a business professional or a professional that guides other business owners on what white-collar crime is all about. Now, in the earlier modules, I told you that I served 26 years in federal prisons, and during that time, I was incarcerated in prisons of every security level. So from 1987 till 1994, I spent time in high security prisons. I spent 1995 and 96 in medium security prisons. I was incarcerated from 1997 to 2003 in a low security prison, and then from 2004 until my release in 2013, I was in minimum security federal prison camps. Now, regardless of where administrators held me, I spent time alongside people convicted of every type of crime. And so we should understand that there is a difference between white-collar crime and what I would call more typical street-level type crimes. So while I was in prison, as I mentioned earlier, I got an undergraduate degree and a master's degree. And when I was in graduate school, I studied many courses that taught theoretical concepts about criminology and the criminal justice system. And theorists from as far back as hundreds of years ago would write about there being two different types of crimes, mala in se and mala prohibite. So basically, those theorists described mala in se crimes as the type of actions that we would consider criminal in any era. Didn't matter when that era was, because regardless of the political climate or who was in charge or in power in a given community, we would always consider acts like murder and robbery and burglary and arson to be really criminal behavior. And those crimes victimize people or they damage property values. And so that's why they're always a crime, because they're always creating a victim. And the theorists refer to a different type of crime as being mala prohibite. They're different from the others. The others are mala in se, or to translate from the Latin, mala, they're just bad. They're bad, they're inherently bad and evil. But mala prohibite crimes really constitutes behavior that may be against the law in one era, but not against the law in a different era. For example, in ancient Greece, lawmakers imposed the death penalty on people from the higher classes if they were to teach people from the lower classes or the slave classes. And that's something that Socrates learned. And I learned a great deal from Socrates. When I began my term in 1987, I met many people that were serving life sentences for selling marijuana. But today, many states have legalized marijuana for recreational use. Times change. And when times change, laws change. Consider a couple of examples from history, not too distant history. When Hitler reigned over Germany, the law made it a crime to provide safe harbor to Jewish people. Yet Hitler's law made it legal to kill Jewish people. So this shows us that just because something is a crime isn't necessarily an arbitrator of whether something is good or bad. American law once made it illegal to provide safe harbor to a person that had escaped from slavery. That was against the law. But our laws made it legal to enslave other human beings. So, we can see that just because a legislator makes something a law doesn't necessarily mean that it's good or bad. It could, and with mala prohibite crimes, it could be just a sign of the times. History shows us that political leaders may deem certain behavior criminal, but their decisions are not always right or just. They have the discretion to choose of what is going to be a crime. We could, similar as representatives of the executive branch of government, prosecutors have enormous discretion, just as political leaders do. Those leaders may choose to bring charges against some people, but decline to bring charges against other people. For example, prior to becoming president, Donald Trump participated and led a venture known as Trump University. And through Trump University, the venture collected millions of dollars from gullible consumers. Those consumers were led to believe from the marketing materials that Trump distributed that they were going to become millionaires. The consumers went into debt and they felt deceived. Thousands of people that did not have political power, on the other hand, are serving time today in federal prison as a result of convictions for deceiving consumers. Despite having ample evidence against him, prosecutors chose not to prosecute Donald Trump. And when the voters elected Trump, he paid a $20 million civil settlement, and the case involving Trump University miraculously went away. Other people without political power were not so fortunate, and they were charged with white-collar crimes. Our system isn't always fair. Prosecutorial discretion results in some people facing charges that powerful people do not have to face. Consider the real estate housing bubble that led to the Great Recession. Many relatively small-time people served sentences in federal prison for mortgage fraud, yet few powerful bankers or lenders faced criminal prosecution for white-collar crimes. So what are white-collar crimes? Well, while studying crime and criminology, I read a sociological theory by Edward Sutherland, and he proposed this theory several decades ago. At the time, conventional theorists held that poverty and despondency caused crime. But Professor Sutherland disagreed. He argued that it wasn't only poverty or desperation that caused crime. Sometimes greed caused crime. In fact, we now have a show that's very popular called American Greed. Professor Sutherland referred to business leaders and people of high social status that manipulated transactions to their benefit. Those people he would call really white-collar criminals, or people who convicted white-collar crimes. And that's where this term originated of white-collar crime. But the law in and of itself does not provide an official definition for white-collar crime. Broadly speaking, the system categorizes white-collar crimes as being nonviolent, illegal activities that, for the most part, use deceit, deception, fraud, or misrepresentation to obtain money, property, or some other advantage, or to conceal other wrongdoing. So let's talk about crimes and investigations and how they begin. Both white-collar crimes and investigations share certain characteristics, including intent. Now, theoretically, all criminal cases require prosecutors to prove beyond a reasonable doubt that the defendant had bad intent. Yet again, thousands of people serve time in federal and state prisons, and despite their insistence that they did not intend to break the law and they did not even know they were breaking the law, they face criminal charges. But in other types of crime, like street crime or violent crime, the investigations take place at the scene of the crime. There isn't this long trail ordinarily of email exchanges and bank records and so on. Law enforcement officials get a report and then they collect evidence on the scene. But with white-collar crime, the evidence flows from a very long paper trail, including emails that went out, bank statements that go out, contracts that people sign, marketing materials that are distributed, websites that people build, different transactional recordings. See, the investigators have a solid body of evidence that they can assess, and it can lead them to call upon people as either witnesses to an investigation, subjects of an investigation, or targets of an investigation. If a person gets labeled a target, there's a very good chance that an indictment for a white-collar crime is going to follow. A witness may be able to shed some light on the evidence, and the subject may or may not be part of the crime. That investigators are going to make that assessment as they continue. But investigators will identify a target. When they do that, it's very likely that that person is in pretty big trouble, and they're going to have face a criminal charge. Now, once investigators conclude that a person or a company has engaged in criminal behavior, they will begin to work with a prosecutor. And the prosecutor will likely convene a grand jury. The grand jury consists of a panel of several ordinary citizens. They listen and observe while prosecutors present the evidence. The grand jurors also may ask questions of the witnesses, and defense attorneys will not be present to argue on behalf of the corporation or the targets. It's just going to be the prosecutor, the witness, and the members of the grand jury who are going to participate in this gathering of evidence or assessing whether it's warranted to have a criminal charge. The grand jury, that's what they do. They serve the purpose of determining whether probable cause exists to charge people or corporations with crimes. Prosecutors will ask the members of the grand jury to return an indictment that officially charges a specific crime, and they can bring that charge against a human being, a person, or also the company itself. If the grand jury indicts a corporation or an individual, in most cases, the defendant will accept a plea agreement in exchange for a lighter sentence. Those who choose to plead not guilty may face either a bench trial in front of a judge, or they may face a regular jury, also known as a petite jury. Sanctions and collateral consequences can be enormously severe after a finding of guilt. They can include fines, injunctions, forfeitures, disgorgement, imprisonment, loss of professional licenses. They can include reputational damage and just personal devastation and stress that really influences not only the individual, but the individual's family members as well. And for these reasons, we really believe it behooves business leaders to learn more about the options they can use to avoid criminal charges or to qualify for leniency if the government begins to investigate wrongdoing. This is just so crucial, and it's so self-evident for people that are members of our team at Compliance Mitigation, because we've all gone through a government investigation, and we've all served time alongside other people who went through government investigations and then found themselves in federal prisons. We want to help lessen the vulnerability of people, and frankly, we need the help of other people that serve the business community. And we want to provide resources that members of your team can use to say, okay, we've got to become more aware, because the more we know about white-collar crime, the more we can potentially implement policies and procedures to qualify for leniency or a deferred prosecution agreement. So first, business leaders really need to develop an understanding of white-collar crime. And members of our team have conversed with countless business leaders who said they didn't even know they were violating the law, which is why we want to provide this information. Now, many people that worked in a business setting could not conceive of themselves as being criminals. They said that they did not have any intent of breaking the law. And for these reasons, we want to help more business people understand white-collar crime and the complications that follow. The more business professionals understand, the more vigilant they can be. So to protect the business, leaders may want to implement clear policies to show their team members what they should do if they witness behavior that investigators may construe as white-collar crimes. Effectively, prosecutors, as you're going to hear about in a future module, really want to turn all members of the workforce into quasi-members of law enforcement agencies. If they see something, they should report something. And if a leader understands that if they can systematize that teaching and that training, then those leaders are going to go a long ways towards qualifying the business and the other leaders of that business for leniency or mercy, and perhaps even immunity from prosecution with non-prosecution agreements. Now, in order to implement this training, business leaders, first of all, have to know what is white-collar crime. And I'm going to start by just talking about mail and wire fraud, two of the most common types of white-collar crimes. Now, they're popular because prosecutors can bring them against anybody. They're rather easy to understand for a jury. Although many business leaders I met in prison said they did not understand their behavior could lead them to prison, if they understood the concept of mail fraud and wire fraud, they would know a lot more. Because prosecutors simply need to prove that a person engaged in some type of a scheme to defraud a victim And at some point, the defendant either used the telephone, the internet, he sent or received something through the mail, and that is going to be sufficient conduct to justify a charge for mail fraud or wire fraud, which is a typical white-collar crime. But there's a lot of other types of fraud, right? Mail and wire fraud have enormous reach, and they're applicable to any type of business. But most all businesses use the internet, the telephone, and the mail. If a bank sends a statement, for example, and the statement includes information about bank transactions that involve proceeds from a fraudulent sale, prosecutors may choose the broad category of mail fraud or wire fraud. But prosecutors could also narrow things down to choose a very specific kind of fraud. For example, if a person used inaccurate information to complete a mortgage application, prosecutors may charge mortgage fraud. If a person filed an application for a loan at a bank but used deceitful information, for example, the person inflated the value of properties when it came to telling the bank what it's worth to pledge it for collateral, but decreased the value of the property for purposes of taxes, that person clearly committed a fraud, and they could charge bank fraud, they could charge wire fraud, they could charge tax fraud. There's just so many. Physicians have these problems with healthcare fraud. But the prosecutors have so many tools at their disposal, as we've described in other areas where there are thousands of laws on the books, the prosecutors have a lot from which they can choose. It's important to help others understand these laws and be on the lookout for those laws and be able to demonstrate that a company has a systemic method of training so that God forbid if the company's ever under an investigation, they can show a commitment to transparency and compliance. So another white-collar fraud is honest services fraud. Both business leaders and elected officials may face charges for honest services fraud. In fact, I think it was Kenneth Lay from the Enron scandal faced charges for honest services fraud when prosecutors alleged that as CEO of Enron, he had a duty and a responsibility to provide honest services. And they said that he did not, and he was charged criminally for that behavior. But under this statute, prosecutors must simply show that a person has a duty to provide honest services to its stakeholders or constituents. And those constituents may include voters or shareholders or consumers. If the person makes deals to benefit himself or misuses his position or misallocates assets or self-deals in any kind of way, prosecutors may want to allege that the person deprived people of honest services. Then there are conspiracy cases. Prosecutors may charge conspiracy when two people agree to engage in a crime. They don't necessarily have to complete the crime. They simply have to agree to commit a crime and then take some kind of step in furtherance of completing the crime. For example, an accountant may agree to create financial statements that support a defendant's scheme to defraud a banker, a lender, an investor, and the accountant could be brought in under charges of conspiracy. Prosecutors could charge a person with conspiracy if they believe one person helped another person carry out any kind of crime. So, just consider a corporate executive that tries to raise money. If the executive hires a graphic designer to create a pamphlet that provides some type of inaccuracy that could theoretically mislead investors, even the graphic designer could be brought into a criminal charge for conspiracy of wire fraud, mail fraud, securities fraud, tax fraud, any kind of fraud, money laundering. The inaccuracies may just be stock photos or fake biographies or fake financial statements. It's important to understand this because there are serious criminal liabilities that attach to anybody who's affiliated with a crime. Now, there's bribery and corruption and Foreign Corrupt Practices Act. If a person gives something of value to a politician or a business leader with a specific intention of influencing favor or skirting rules of some kind, that person may face charges for bribery, corruption, or violating the Foreign Corrupt Practices Act. And if a person conspires with someone else to violate those rules or to self-deal in some kind of way, there's definitely going to be a follow-up with criminal charges. And there's securities fraud and insider trading. So a person that works in a publicly traded company has specific duties and responsibilities. And sometimes violating those duties or responsibilities can lead to criminal charges for violating securities laws. If investigators believe an official misleads investors, prosecutors will bring charges. If someone receives information about a publicly traded company and that information has not been made known to the general public, but then the person purchases or sells stock based on that information, the person can face criminal charges. That's particularly relevant to accountants who deal with financial statements. So what about tax evasion? Tax evasion, of course, just refers to various activities that may result in the willful, deceptive avoidance of paying taxes on income. And as with all types of crimes, prosecutors can also bring conspiracy charges if they believe that one participant, such as an accountant or a financial advisor, willfully participated in helping a person or a corporation use deceitful means to underpay taxes or avoid paying taxes. And then there's perjury, or obstruction of justice and lying. See, the Fifth Amendment of the Constitution protects a person from having to respond to any questions from law enforcement officers. If a person feels that responding could potentially lead to self-incrimination, the person just simply has to respond by invoking the Fifth Amendment. On the other hand, if a person does respond to law enforcement, that person must communicate honestly. He doesn't have to be under oath. If the government investigators or lawyers think the person is lying, they can bring criminal charges. And the person, could be somebody like Martha Stewart, who got a tip from her financial broker that somebody was selling stock that she owned, and she then sold her stock. She was not charged for insider trading. She was charged for obstruction of justice, because when investigators began asking her questions, she lied, and that resulted in her becoming a felony, and also a person convicted of a felony, and also a person who had to go to federal prison. Cost her a lot of money, a lot of reputational damage, and so people need to know about these types of white-collar crimes. And then there's money laundering. Statutes involving money laundering applied broadly to all financial transactions involving criminal proceeds. If the transaction promotes criminal activity, evades income taxes, or seeks to avoid the reporting requirements on currency, prosecutors can bring charges for money laundering. It's a simple act as opening a bank account could be sufficient to bring a charge for money laundering if prosecutors allege that the money that was deposited into the account, or even was intended to go into that account, was stemmed from illegal activity. So it's important to have a concept of jurisdiction as well, because in America we have many different jurisdictions, as I spoke about in the first or second module, and those jurisdictions can result in criminal charges against people or corporations. The United States Code includes more than 4,000 statutes that can lead to criminal charges. And besides the federal system, every state in the Union has its own criminal code. And the District of Columbia has a criminal code. The military has a criminal code. So besides all of those statutes, representatives of our government have published more than 1 million pages of regulations, and all of those regulations can lead to criminal charges of either people or corporations. And so these are the reasons that we highly recommend business leaders invest the time and the energy to understand how the government brings investigations that can lead to sanctions or charges for white-collar crimes. And that information would prove helpful to all honest business leaders that want to minimize exposure to such investigations. Now, the next module, we're going to talk about, I think it's going to be about what prosecutors want to know. But before we get there, I'd like to leave you with just a couple of questions, simple questions, no big deal. And that the first one is going to be, how does the law define white-collar crime? A, is it white-collar crime involves people that work in professions? Is it B, the law does not define white-collar crime? Or is it C, white-collar crime results in the loss of money for victims? Or is it both A and C? That's my challenge to you. What's the best answer? How does the law define white-collar crime? A, white-collar crime involves people that work in professions. B, the law does not define white-collar crime. C, white-collar crime results in the loss of money for victims. Or D, it's both A and C. Second question, what is the purpose of a grand jury? A, the grand jury assesses whether sufficient probable cause exists to charge a person or a corporation with a crime. B, the grand jury determines whether a person is guilty or not guilty. C, the grand jury determines whether a corporation is guilty or not guilty. Or D, both B and C. Again, what is the purpose of a grand jury? A, the grand jury assesses whether sufficient probable cause exists to charge a person or corporation with a crime. B, the grand jury determines whether a person is guilty or not guilty. C, the grand jury determines whether a corporation is guilty or not guilty. Or D, both B and C. Those are your two questions for this module, and we'll be back with the next module right after this. Thanks.